Good morning. I would like to acknowledge and extend my gratitude to the AHALJ, its president and executive director, and of course our German hosts for giving me the opportunity to be here and share with you our experience in this litigation against the internet giant. The title of this panel reads the recent Google case, but in fact what we have as of today is a case in progress. It's worth bringing it here and now because it's a whole new experience for DIA and also because we can draw some tentative conclusions. As Marcos told you, DIA is the umbrella federation of the Argentinian jury founded in 1935. Deals mostly with advocacy issues, fighting anti-Semitism and supporting Israel in the political and legal fields. It's a member of the World Jewish Congress and the Organization of the American States as an NGO. DIA brought this case as a change in its policies. Historically, they only litigated at criminal courts reporting specific anti-Semitic episodes against individuals. It did so because under the Argentinian law, it is a crime to perform any positive act of discrimination when, of course, other conditions are met. And discrimination is also an aggravating circumstance to any other crime. However, the threshold that the law imposes in order to commit to trial someone is so high and the wording of the act is somewhat confusing that it's very difficult to be successful at a criminal court. This slide shows the DIA's recent reporting activities to authorities, and this one comes from a study that DIA did this year. It shows the nature of the reported episodes, and as you can see, surprisingly, although anti-Semitic acts increased during periods of problems in Israel, the main causes are not previously linked with what goes on in the Middle East. Well, to prevent such a stiff test under the Discrimination Act, we brought a case under the General Civil Law. Under the civil law of discrimination, any person who discriminates another for any reason can be ordered by a court to stop doing so, and of course to pay damages. That is the typical torts law effect. Of course, this rule needs to be construed in accordance with the freedom of speech clauses. At the end of the day, DIA is looking for a definite ruling about the collision of both rights and the game that an internet search engine is believed to play. And this will help their daily life. Let's suppose tomorrow there's an open call to attack any minority, and the question is, should Google help stop such a movement? So the litigation is in progress. Unless we settle before, I think we will end up with a decision by the Supreme Court. The other innovation is that we set out the case as a class action. That is to say, not only DIA, but DIA as represented as a representative of the whole Jewish community. And we brought a lawsuit against Google USA because of their businesses in Argentina. So claiming well, a collective standing, DIA requested Google to review some suggested searches, to stop including paid ads in certain anti-Semitic sites, and to remove from the search engine some 65 sites, and of course of discriminatory content. And we chose to skip the claim for damages at this time. You may realize that the anti-Semitic content in the internet is much larger, but we didn't want to lose on the grounds that our request was too wide or ambiguous, as the case law suggests. To bring here some example of what we brought to court, look at these cases. When you type in Judío, Jewish at Google, it opens out a window where Google suggests you to look for Judío jabón. It's Jewish plus so. Of course, when you go and search such a phrase, you will have plenty of offending sites. So let's say if it's a young student at school who wants to know what a shoe is, she might end up browsing through those sites. The same applies to several other searches. As you can see, we're still in the Google website. We proved that typing any word from A to C after Jewish, Google will only suggest defamatory adjective from the usual catalog. You can see some examples here. When you look for some topics that have nothing to do with Jews, Google suggests, again, anti-Semitic materials. Plan A completes as Plan Andinia, that is to say the so-called Zionist conspiracy to take over the Argentinian and Chilean Patagonia. Protocols completes with, this one's easy. And see this one, if you type the name of our president, Christina Kirchner, it asks Jewish, of course it's not Jewish, thus prompting you to check for some sites saying that actually Christina is Jewish and a conspirator. In the so-called Google Ads, we certify that in many defamatory sites, there are paid ads by announcers. We do not know if the announcers choose the sites where they want to be, but at the least, they have a duty to know which sites are linked to their brand. This one's from the Hector Timmerman is the Ministry of Foreign Affairs. Look at this example where Volkswagen, the German company, is advertising its cars in a website promoting the protocols. And this other example is of a political campaign from our re-elected president, Cristina Fernandez. Finally, what might be the most problematic issue we raise, we ask the court to straightly remove from the search results many sites. This means that, for example, when you type in, let's say, I love shoes in Google, looking for iloveshoes.com, the engine will not show this site. It doesn't mean that the site is banished from the internet, only that you will not end up there while Googling any word. In this example, when you start typing Plan A, you end up learning that Patagonia is being endangered by, again, the Jewish conspiracy. If we succeed, these sites will be banned, as I told you, will be banned from the engine, but not from the internet. So the real anti-Semites will keep consuming those materials, but at least we make sure that a simple passerby will not end up there. We were very careful in only including sites that were completely undoubtedly of a discriminatory content. Show you here some examples. This is the Patagonia, and I think it's a rabbi breaking the country. And that's our two last presidents in this Jewish conspiracy. We excluded, as it is said here, critics about religion, anything that it's really an academic discussion, artistic expressions, humor, and even political attacks against Israel. And the issue of the Holocaust denial was a problematic one. Although there are some cases in our case law, in our side, it is contested whether the denial act is deemed to be discrimination under the current law. To avoid this discussion, we only included sites with the conspiracy version of the Holocaust, which clearly implies effects in the present. So after filing the complaint, which took place in May this year, we asked the court to ban access to those materials as a matter of a preliminary relief. The judge, Molina Portela, agreed with us and ruled that on this preliminary stage, he saw that no freedom of speech privilege could be brought, and Google couldn't reverse that ruling at the appellate stage. Just before serving Google, the press agency of the Supreme Court made the ruling public. That's the whole statement, I guess. And in the next